All right, thanks, Carlene. Good afternoon. Good afternoon. I'm Professor Roy Gardner from Stetson Law School. I'm also the director of the Institute for Biodiversity, Law and Policy, and it's a pleasure to be back here at this conference. I've been to almost every one. I just find it invigorating. You know, some people up here have made a distinction between the real world and the government. I'm in academia, all right? This is all the real world. So I appreciate everything that you all do, and I very much appreciate Carlene and her team for putting this together. So if we could thank them, please. Now at this policy roundtable, usually my role is member in the audience asking an awkward question. But apparently I've been promoted. I'm not sure that's a good idea. I don't know if you want to encourage that, but I thank you for the opportunity. So we have great panel here. I am going to briefly introduce them. Usually what I like to do at my first class, when I first meet the students, is I ask them to introduce themselves and give me one interesting fact. So I have one interesting fact about each of them as well. All right, so first we have Lisa Dawson, who is currently acting as the Deputy Division Chief of Decision Support, Planning, and NEPA for BLM headquarters. And prior to joining headquarters, she worked as the Deputy District Manager for the BLM's Colorado Southwest District. Her interesting fact is she is an avid skier and loves the sport, and that's why she broke her ankle. Next we have Jason Miller. Jason is a biologist in ecological services with the U.S. Fish and Wildlife Service headquarters, where he focuses on national mitigation topics, including mitigation policies and regulations. He has also worked in field offices in the Northeast region on civil works and island restoration projects. Jason's fact is that he started his natural resource career working for the St. Johns River Water Management District, but is not responsible for the Kuntz case. That's a Florida joke. Then we're also joined with Angela Somma. Angela has been the chief of the Endangered Species Division, Office of Protected Resources with the National Marine Fisheries Service since 2005. As division chief, she oversees national programs and policies to implement the ESA for marine and anadromous species. Angela's interesting fact is that she has represented the United States at a number of international meetings, including the Conference of the Parties for the Convention on the International Trade in Endangered Species, known as CITES, including their most recent COP in Panama, where a new marine turtle resolution was passed. Next, we have Betsy Valente, who has served as the Chief of Freshwater and Marine Regulatory Branch at EPA headquarters since November 2021. Betsy manages efforts associated with EPA's Clean Water Act, Section 404 regulatory program, as well as EPA's Marine Protection Research and Sanctuaries Act program. And Betsy's interesting fact is that she has conducted research in the Brazilian Amazon and the Great Barrier Reef. And then finally, we have our representative from the Corps of Engineers, Tom Walker. He is currently the acting chief of the Corps' regulatory program. Previous to this assignment and since 2011, Tom has been the chief of the regulatory branch in the Norfolk District in Virginia, and he also spent 16 years as project manager and supervisor in the Wilmington District in North Carolina. And his interesting fact is, after surviving 3 teenagers, 2 guinea pigs, a snake, a cat, and a bearded dragon, sometimes all loose in the house at the same time, he has learned the value of being boring the rest of the time. So thank you all for joining us. And so I've got a number of questions here that I'm going to ask, but if you have questions, you'll have an opportunity to ask them from the floor, or you can submit them, and I'll perhaps read them from the iPad. Okay, so we'll start with some easy questions and then progress to slightly more difficult questions. All right, first question: what happens if the federal government defaults? Oh wait, no, I'm sorry, that comes later.
Right?
That comes later. All right. Now we'll start with an easy one. All right. As President Obama once said, elections have consequences. Priorities and policies shift under every administration, and throughout the conference we've heard a little bit about what's in the pipeline, but what would you like to highlight? What are the regulations and or guidance documents that are currently under consideration in your agencies that are most relevant to the folks in the room? And start with Lisa.
Okay, so I think I'm going to start a little bit with what we've been up to since the Biden administration took office, where we've been reissuing a lot of our mitigation policies. Starting in 2021, we reissued our mitigation manual and handbook, which requires compensatory mitigation for residual impacts on any important, sensitive, or scarce resources as identified in our resource management plans, or that are legally required or mandated, like Endangered Species Act and the like. It also encourages sort of the landscape scale mitigation, so looking for those larger projects over a bunch of similar ones, and so you're taking the whole landscape into consideration. Another thing that came out is our Office of Solicitor, which is our attorneys, issued a memo which reaffirmed our authority to require appropriate mitigation, to identify mitigation resources and appropriately require them. In the previous administration that had been reversed. So we reissued that in 2021 as well under the Federal Public Lands Policy and Management Act. FLPMA. Also on sort of the secretarial scale, jointly with the Department of Agriculture, we issued, and I'm going to read this a little bit so I don't mess up the title, the Fulfilling the Tribal Trust Responsibilities to Indian Tribes in Stewardship of Public Lands. And this one is really quite cool because it requires us to incorporate tribal expertise and indigenous knowledge to all of our decision-making processes. And so we've been incorporating that. It also lends itself well to co-stewardship, where we're engaging more with tribes and tribal members to be more directly involved with the BLM and the things going on. And so we're trying to get them more integrated into the mitigation process. But probably the biggest thing that we're doing at the moment outside of that one is that on April 3rd, 2023, we released a proposed rule on conservation and public land health, what we affectionately call the Public Lands Rule. And this one's kind of a big deal for those in the audience because it really brings mitigation into focus as a means to help us conserve and restore our public lands. The purpose of this rule is to establish a framework that provides for healthy landscapes, wildlife habitat, clean water, as well as informed and balanced decision making. This is a proposed rule. We're in the public comment period, so anything I say is, it's not final yet. We're working through a lot of things with that. But I wanted to sort of highlight some key points here. One of which is that it brings conservation to the same level as other uses, such as oil and gas and the like. It brings it to the same level and on the same field as those uses. Also, it introduces conservation leases. And what that essentially is when a third party can approach the BLM to come into an agreement to lease the landscape for the purpose of restoration. And this could be wildlife habitat, and so you're bringing things back so it can support a mule deer, whatever that might look like. That's what the conservation leasing is for. Also, more details about it is it's got a 10-year primary term, However, that can fluctuate depending on what you're doing and whether or not the goals of the lease have been made. So it can be decreased or increased accordingly. Making sure I got it. Also, this is a little bit in response to feedback we got on mitigation because it ensures there's a reliable path for using mitigation through the conservation programs within BLM. In the Federal Register notice, there are a series of questions that ask the public to comment directly on conservation leasing, on whether that's the appropriate term to use, the dynamics behind it, like how do we determine the fair market value of the resource when we're doing conservation leasing. So as you take a look at this rule, we'd really like you to sort of respond to those things. And if you have more questions about that, it's on the regulations.gov sort of lists questions that we are truly seeking public input on that one.
Great. Do you know when the comment period closes?
It closes on June 20th, but that could fluctuate if we end up with more public meetings. That's the only caveat, is it's June 20th or 15 days past the last public meeting, kind of. So sorry. The third point that I wanted to make is that it really provides a framework for mitigation. We have mitigation scattered throughout our regulations, it's in the statutes, it's in our policies, but it also gives a piece for mitigation generally. And one of the key points is that it does articulate that it follows the mitigation sequence, so what the CEQ requires. It also requires mitigation for those important, scarce, or sensitive resources as identified to the maximum extent. And it allows authorized officers to enter into agreements with qualified fund holders to establish mitigation accounts. And this can either be for resources with multiple projects or those small projects that have large compensatory mitigation requirements. My final point on the rule is that it has some language on areas of critical environmental concern. And what's important about paying attention to this part of the rule is ACECs combined with lands with wilderness characteristics, as well as our national conservation areas, are really where we see mitigation to be quite suitable. So outside of that, right now, again, as we mentioned, public comment period. It's closing June 20th unless we have more public meetings. We do have public meetings scheduled, the first of which starts on May 15th, and it will be virtual. One on May 25th in Denver, May 30th in Albuquerque, June 1st in Reno, and June 5th again virtually. And more information will be coming out on that from BLM. And go to regulations.gov to provide comments.
All right. Well, thank you. It's a lot going on at BLM.
Yeah, thank you.
What's going on at Fish and Wildlife Service?
Well, in the Fish and Wildlife Service, we certainly felt how elections had consequences with respect to mitigation policy. In the Obama administration, we had put out 2 mitigation policies. One was our agency-wide policy that updated our 1981 policy, which is, at least at this moment, still in place right now. To go along with that agency-wide policy, we put out an Endangered Species Act compensatory mitigation policy that we then, in 2018, had to withdraw. So there's certainly an acute consequence there, but like BLM, we endeavored to reissue both of those policies. And I'm happy to announce that if you are in the habit of visiting the Office of Federal Register reading room, you can do it digitally now. It will be there tomorrow morning. So it's good news, yes, tomorrow morning, thank you. And it will publish on Monday. So it'll be one notice that will have links in the notice that will point to 2 service manual chapter locations where the 2 policies will live. And so that's the end of a long road. We're certainly hopeful that these policies will be durable and won't be subject to this back and forth between administrations. And as I said, the service-wide policy, we're leaning on a 1981 mitigation policy, and obviously we need to have some contemporary thinking in place for policy. And just as a story, when you're on your way home and you're looking down from your window seat at our, moth-eaten landscape, then you see ecological space and habitat, and you see maybe agricultural space, and then you see space that's dominated by human infrastructure, human uses. Well, the latter two were converted from habitat at some point in the past between 1492 and yesterday. Well, as it turns out, more than a third of those conversions happened since 1982. So in recent decades, our foot has really been on the gas. So we're excited to hopefully secure more effective mitigation by providing our staff with contemporary guidance. So policies are happening. We're excited about that. We're also, as Sarah Johnson and others pointed out, we're working on regulation. And so this would be specific to conservation banking, but we'll also address ILFs and PRM. And that is underway. We published an advance notice last year, and we are developing the reg right now that is addressing the feedback we received from that ANPR.
I see. So it's probably a little too early to say whether PRM, in lieu fee, and mitigation banks will be held to equivalent standards, or whether there might be a hierarchy.
It's not too early to say. We will uphold equivalent standards between the mechanisms, Professor. That's a principle that you'll see in our policies tomorrow, but the reg will underscore that. But like the 2008 rule says, for the course part, they're equivalent but not identical standards. Right. So there may be necessary differences in the way procedures are managed between the three mechanisms.
Great, thank you. Angela, what's going on at NOAA?
Yeah, so it's been a very active time at NOAA. Last year, NOAA issued its first ever mitigation policy, which guides our mitigation responsibilities and programs, both within the National Marine Fisheries Service and our National Ocean Service. As Susan Marie Stedman had described earlier this week, we've also issued a procedural guidance to help implement that NOAA mitigation policy. And so that's primarily designed for our staff to lay out the considerations and that they need to take into account when they're implementing the provisions of the policy. In our Endangered Species Program, we are reviewing and revising a number of the regulations that were put in place in the last administration. Last year, there's several of them are joint ESA regulations with the U.S. Fish and Wildlife Service. Last year, we rescinded the regulatory definition of habitat, which was meant to apply to critical habitat and designating areas as critical habitat. Today, the Senate voted under the Congressional Review Act to rescind that rule, but the President has said that he will veto that should the House also pass that resolution, which is expected. Early next month, we expect to issue proposed rules to revise the Section 7 as well as the listing and critical habitat joint ESA regulations. Those are in the last phases of review in the interagency process at OMB. And then within NOAA Fisheries Endangered Species Program, we sort of have had a resurgence and revitalization of our program. We're updating our guidance having to do with how to take climate change into consideration in all of the ESA determinations and decisions that we make, and that should be issued within the next week or so. We've updated our handbook for developing recovery plans for our listed species, and we have increased the number of recovery plans that we've been putting out. We have a number of critical habitat designations that are either proposed or in the interagency review process. So, we developed quite a backlog in the last administration. It was very difficult to designate critical habitat, and so that's being revised as well. And in addition, we have increased our ESA listing activity, and we have gotten through a number of our backlog is not nearly as significant as the Fish and Wildlife Services, but we are starting to work through the backlog that we did have for assessing species for listing under the ESA.
Great, a lot of activity as well. What's going on at EPA, Betsy?
I'll start with an item that was already highlighted today. On December 30th of last year, EPA and Army announced the final revised definition of the Waters of the United States rule. And on January 18th of this year, the rule was published in the Federal Register and took effect on March 20th of this year. However, the final rule is not currently operative in certain states due to litigation. The agencies developed this 2023 rule with consideration of relevant portions of the Clean Water Act as well as the statute as a whole, relevant Supreme Court case law, as well as the agency's technical experience after more than 45 years of implementing the longstanding pre-2015 Waters of the United States framework. Additional information is available on EPA's website about the status of the rule as well as litigation. In addition, EPA is currently working on proposed revisions to our regulations for Clean Water Act Section 404G regarding state and tribal assumption of the Section 404 program, and is also working to finalize revising the Clean Water Act Section 401 water quality certification regulations.
Thanks. Yeah, WOTUS. You know, some people can make a whole career out of that. Tom?
And speaking of a career out of WOTUS, so yeah, there's that. The WOTUS, as you know, Army participated in the development of that regulation. What the Corps has been doing is developing implementing materials and direction for our field there. In addition, last summer, the Assistant Secretary's office put out a Federal Register notice on modernizing civil works for the Corps. They requested comment on a myriad of things. A few items that have sprung from that so far is the Assistant Secretary's office did issue guidance to the Corps on including environmental justice in consideration on civil works projects. That specific guidance didn't cover regulatory with the promise of further specific guidance for regulatory to come, but there are principles in there certainly that we can incorporate in our program and are. We're also working, as Mr. Connor announced a while back, on a proposed regulation to remove Appendix C, which is the Corps' regulation for implementing Section 106 of the National Historic Preservation Act, and simultaneously put in place a memo to the field, a direction to the field on how to implement that specific to the Corps regulatory program to make sure our scopes are aligned. And then Mr. Garner's office is also working on a tribal consultation policy for the Corps that will include regulatory and reinforce our commitment to working with the tribes and including them in our process and building those relationships.
All right, thank you. Well, there's a lot going on at the agencies, and so that begs the question, who's going to implement all of this? And a recurring theme that we have heard throughout the week is a concern about staffing. You know, even if there's enough money to hire, there's a question of who are you going to hire when the unemployment rate's at 3.4%? And as we heard in the last session, Mike Rolban talking about, what do you do about trying to retain your employees? So I open it up to anybody on the panel if you want to talk about what challenges are you facing in terms of hiring and retention and what might be done about it? And do you see, are young people still drawn to government service?
Well, I can start.
Yeah, please. All right.
So NOAA did get $20 million in the infrastructure bill for permitting resources, and we got another $20 million in the Inflation Reduction Act for permitting. That funding has still working its way through our department. We haven't received the IRA funding, but we have received the infrastructure funding. The challenges with that has been, while it's a big help, it's temporary funding, so we are hiring term employees. We've received funds to hire people, but the other sort of infrastructure within NOAA has not received any increase in funding in many years. And to hire people, you have to go through our personnel department, so they're very much backed up. To hire contractors, you have to go through our contracting office, and they have not received any increase in funding. So it can take a very long time to get a position advertised on the street. And then once it is, the federal system for hiring people can be very lengthy. And as you said, the job market right now is very strong, and a lot of candidates aren't willing to wait 2 months to get a job offer after they've interviewed with you. We've also found within our department the telework policies and the lack of ability for remote work has been a real challenge, both for retention and for particularly new employees. They, you know, Washington, D.C. is a very expensive area, and a lot of people don't really want to move to the D.C. area, and so that has been a real challenge for us as well. You know, the work that my office does, there's still a lot of interest in endangered species protection and marine mammal conservation, so there are a lot of folks coming through academia who are very interested in our work, but just getting them on board, and then, like I said, some of the policies around being in the office and that sort of thing has been a real hindrance for us.
Yeah, I mean, that's just a challenge with culture in any workplace now, is how do you build a sense of community if people are starting by telecommuting or teleworking. Do you want to?
Yeah, I was going to pretty much, with the BLM has experienced a lot of what you just articulated there as well. We are too taking some of the IRA funding to increase capacity in our contracting and our HR departments, because they're the ones who are going to be processing a lot of this work. If we're going to get staffing in the field in order to implement, we need HR to get the staffing and contracting too. And that's been a big priority for our executive leadership team, and they're tracking our vacancy rates, and especially with that HR part of it, to get those a little bit more robust. Recognizing trying to bring in people at lower levels. We've got policies now in place in different parts of the organization that require us to look at, in the federal government, where you're hired at a lower level than the full performance level. So we call them the career ladders. So you can be a 7, 9, 11. And hiring at that 7 and not just always going straight to the 11 to try and grow people into the organization. We also, this past April, had a push to hire 100 interns, and so that will then give us a nice pool to recruit from, where we can, and apologies for people who don't understand the expression, but I would say hungry hippo people in. It's where you don't have to go through the USA jobs process, and you can pull people into the federal government because they've been vetted previously. And so by getting
Are those paid internships or volunteer internships?
They're paid internships. And so then they spend the summer and then get the hours in that they need to, so that then they are qualified to be moved into federal service or to compete as a non-competitively. Because that can be one of the struggles too, is to get robust candidates from the public at large pool, which we're working on, trying to figure out ways to tighten some of the language we use in our job announcements to recruit generally the people you need for those positions.
We have a big challenge in the Fish and Wildlife Service, certainly. We didn't share in the funding that has gone to agencies that either put steel in the ground themselves or permit it. So the monies for environmental review processes under our various authorities, our mitigation authorities, is really unchanged. And even without the large new initiatives, there already is a crush. We have, in real numbers, far fewer people than we did 20 years ago doing environmental review. The field offices have fewer people, and we also have more listed species in that time. So then you add on top of that, the projects likely to surge our way from transportation, civil works, et cetera, and there's not really a great answer. We are trying to be creative in working with individual agencies where possible to develop transfer funding streams with the Forest Service. Others, we're working with Corps headquarters right now to see if we can develop a new process under the Fish and Wildlife Coordination Act, which already gives us transfer funding capability, but to reconceive that to give us more predictability and capability that we have. When they knock on the door, we'll have people available. But also, like you said, who are we hiring? That's a big challenge too. And if you want people to review very complex, consequential, large projects under multiple authorities, and you're hiring a new biologist as a 2-year term, you may have a challenge.
Betsy or Tom, did you want to add anything?
EPA did not receive additional personnel or resources in the 404 program associated with infrastructure funding. However, there still seems to be very strong interest in the type of work that EPA does with regard to streams, wetlands, and those items, including through our internships programs. We continue to try to look for creative ways to increase efficiencies, and EPA continues to have strong interest in working on tools to support efficient and improved compensatory mitigation reviews and outcomes. So we're trying to put our focus there at this time.
Yeah, and I'll open maybe by saying that I do know the answer to Mr. Woodley's questions that he asked in the earlier session, but I'm going to leave most of them alone, but I'll focus on a couple. And this is no secret to anybody in the room. The Corps, starting about 2010, for about 9 years, had a flat budget, which resulted in practically a reduction in staff, while we didn't see a commensurate reduction in workload. And so we're having the same problems that everyone's talking about, is you had as much or more work and less people. Fortunately, we did get some funding through the BIL and are able to start building that capacity back. Again, as Mr. Woodley referenced, it's not all about capacity, but some of it is. And so that was the low-hanging fruit that we attacked first, is let's build the capacity back to handle some of this work. It was tough getting off the ground. One thing that we had great success in is we, last September, did a virtual hiring event at a national level through a platform that allowed applicants to come in and apply for various positions in various locations. Screeners from each district could come in and look at that and pick folks they wanted to interview. I think we had around 800 applicants, around 200 interviews, made about 100 initial job offers, and brought on about 50 people. So I think the pool's out there. We did a bit of, as we started creating these positions in capacity, it did a bit of trading amongst districts. But as of last week, since the last quarter of last year, which would have been July of last year, we've added about 98 net FTE to the core roles. So we're having some luck there. I think some of the things that that others have mentioned, rethinking our policies on telework, on virtual work have really helped, because that seems to really draw in recruits now. So I think there are folks out there that still want to come to the federal government that are very interested in what we're doing. But it is a competitive market.
Well, it's good to hear that people are still interested in working for the federal government. I got my start there.
I tell myself that anyway.
So some of the agencies have some funding for through the IRA or the BIL. Is there anything else in those massive acts that you want to highlight or emphasize for this group? It's been discussed in different sessions, but are there any particular aspects of those laws you want to point out, or how have they changed your day-to-day activities, if at all?
So I think I can start that one, just to sort of continue what I was just saying. I think where it's really changed us is it's given us the resources to start acting on things that we've been thinking about for a long time. And as I've sat in different panels and groups and talked to folks in the hallways here this week, there are a lot of things that we can certainly do that, now we have some resources to work with. So it's not all about capacity, it's about looking at our structure, it's about looking at our processes and looking at the tools that may be available or we can make available to make this more efficient. It's about building relationships. Now we have capacity and time to start sitting down with folks and thinking about, what is the right thing to do here, and how do we make this easier and move faster. The information that Steve Martin and Becca Madsen presented, I think on day one, I would like to sit here and say that I can debate their statistics, but I can't. They're right. And we know there's some work to be done there in that space, but now we've got some resources in place and are building a structure to better address it. So I think that's been the big benefit, is finally allowing us to act on some of those things.
Well, NOAA got a huge surge of funding in both the infrastructure bill and in the Inflation Reduction Act. A lot of that is going for Climate Ready Nation, and the speaker at lunchtime from CEQ mentioned some of the grants that NOAA is just issued. Most of that money is going out in grants. In terms of species conservation and restoration, we received $400 million over 4 years for fish passage, and an additional $172 million over 5 years for the Pacific Coastal Salmon Recovery Fund. And in December of 2022, NOAA already announced the first $105 million in grants that we're going to issue. I'm not sure if they've all quite gotten through the pretty cumbersome grant allocation process, but for fish passage projects. And the Pacific Coastal Salmon Recovery Fund has been funded at about $65 million a year for the last decade at least. And we were able to add another $31 million in FY22 to that program, and we'll continue to implement that increase to the eligible states over the next 5 years. So I think there's a real opportunity for us to make, these are significant enough investments that we can really start making some real restoration project and opening up habitat for our species and really starting to move the needle. Over the last really 15 years, most of our increases, if we've had them, have been very minimal, and they've not been enough to really move the needle on some of our restoration needs. So we're very excited about the funding that we've gotten in these programs and think, you know, we can start to see a real difference as a result of them.
Similar for the BLM as well, to segue off that too, where we have a lot of projects in the basically orphan wells. If you think about oil and gas, we have a lot of backlog in the plugging and abandoning of orphan wells, and so we've been using a lot of those funds for that. Also restoring watersheds, which is, you know, using various landscapes to kind of make them more resilient. We have a lot of public lands, and I think we got a lot of the bill and IRA funding, and we've pushed some of it down to grants, grants for wildlife, Endangered Species Act, and so I think that's even open right now, up until about May 16th. Also, there's some for aquatic and terrestrial restoration. We've also done calls out for projects, and so we're sort of nominating focal landscapes that will direct some of those funding to, but they're going through the process and the allocation at this moment, so I don't have what those projects are right now. What I will say is that we are really endeavoring to build resilient landscapes, be they to prevent wildfires or to sustain habitat, and so now's the time to get pretty creative in innovation in your mitigation banking, do your outreach with your BLM partners, and see if there's ways to incorporate that in any of the projects. I think we're pretty open, and if I've heard one thing over and over again, it's to leverage your partners, and so it's the time to really kind of do that.
Anybody want to add anything else? No? Okay, all right. Let's see. Here's an easy question. Ribbits. So who uses ribbits in this room? Okay. All right. A good percentage. Okay. So so now BLM projects are on ribbits. So, why? Right. I mean, there's you know, for transparency, that's good, right? There's a benefit in transparency, but are there broader benefits as well?
Well, we get to see what we're doing, for one, right? You get to track all of your projects and see, is it effective? You can answer calls from Congress. What are your acreage of mitigation that have been used to restore a landscape? Really, this is very new to us, so we don't know all of the opportunities that we will gain from the rivet system yet. We are happy to be working with the Army Corps of Engineers to get the MOU, but we just pushed production out last March. So at the moment, we are training our employees on how to even enter the data, and from there, we can just see the influence that mitigation has on our landscapes and ways to even perfect it. I think that the system will evolve over time, and the BLM hopes to evolve with it. And I know right now that the ability to track it's kind of important. We were docked for a while there, I think, from an internal control review because we didn't have the ability to do that. And so we are working towards being transparent, knowing what the projects do, and then we'll be able to highlight how mitigation just really helps. And it helps us tremendously to get the work that we need done for development to happen, recreation to happen, oil and gas to happen, all of it to happen. And when you mitigate it, what differences those make in the long run.
I think it's great that BLM is now participating in rivets, and we've heard some talk about expanding rivets even further, perhaps to include permittee responsible mitigation. Tom, is that possible? What are your thoughts on that?
So I think it's certainly, once again, going back to the availability of resources now, something we could explore. One thing we have to be careful with, and this may be too in the weeds for this, but just to be technical for a minute. So when I speak to that, that's mitigation for core programs. There are other users in rivets now, and although rivets was developed by the Corps and EPA, as these other users come on, we don't control or pay for what they're doing in rivets. So if there are other agencies that choose to do some of that stuff, that is not something we would influence. But for the core program and mitigation, I mean, that's something we talked about for some time. We really need to get with the districts and understand the benefit, and is that something we want to prioritize doing on the list of things that we have that we want to do.
All right. Let's jump to conservation banking for a minute, and we've talked a fair amount this week about resiliency and responding to climate change. So how are climate change impacts anticipated changes in the range of species, for example, taken into account in the conservation banking process?
I can start just by mentioning how our policies treat climate change, and our Endangered Species Act Compensatory Mitigation Policy, which you can read starting tomorrow, does include consideration of climate change, maybe not as explicit as dealing with changes in the size of species ranges, but maybe more along the lines of climate adaptation. And so it provides instructions to staff. So when we're talking about effective siting of compensatory mitigation, much like the 2008 rule instructs district engineers to consult watershed plans when they're available in order to make a wiser siting choice, we're instructing our staff to consult available conservation plans, and moreover, consult conservation plans that have various characteristics, including that they incorporate consideration of climate change. So it's built in that way. Also, when we're evaluating actions, we talk about in the policy how in some circumstances it might be more advisable to compensate for an occupied site rather than avoid impacts to that occupied site because of what we know about projected land use changes. Maybe that site is going to be very isolated in the future. But also, that site could be hard to maintain because of what we know about climate consequences. Maybe it's on a site where we anticipate extreme erosion due to sea level rise. And so we are directing our staff through those references in policy to take that into consideration. Also in our service-wide policy, when we talk about looking at the durability of mitigation sites, how are we assessing that? Part of what we consider should include whether it's likely to be resilient to climate consequences. So there are a number of places in both policies where we call out climate as something that needs to be a part of our staff process.
Angela?
Yeah, and very similarly, the NOAA mitigation policy explicitly includes, reference to climate change, and when we're evaluating mitigation, whether it's compensatory mitigation or other forms of mitigation, to explicitly take climate change into consideration, use the best available scientific information to try and understand how an area or site may change over time. When we're looking at the durability of that mitigation, both the policy and the procedural directive that we just issued, instruct our staff to, look at climate change considerations when we're looking at durability. But we also talk about in our procedural directive about adaptive management and the role that adaptive management may need to play because of climate change and trying to make sure that it's resilient to the effects of climate change.
Thanks. All right, well, that ends the easy questions. So now we move on to WOTUS. I have a series of WOTUS questions here. Actually, the Supreme Court issued opinions today, issued 5 opinions, but Sackett was not one of them. So I was up in my room at 10 a.m. hitting refresh on the Supreme Court website. So it hasn't come out yet, and I know, Betsy and Tom, you can't talk specifically about possible outcomes of in Sackett and the potential implications for the mitigation banking industry. So let's talk about what happened in the past. Let's talk about past occurrences where the definition of WOTUS has been revised, where it's been constricted or reduced. So for example, in 2020, in the Navigable Waters Protection Rule, that reduced the geographic scope of the Clean Water Act. And it was reported in some cases that permittees, they had their permit, but they surrendered their 404 permits, believing that their projects were no longer subject to the Clean Water Act. So let's assume the following scenario. A developer is granted a Section 404 permit to fill some streams and wetlands. And the permit is issued on the condition that permittee responsible mitigation be provided. Let's say on-site restoration. And then for whatever reason, after the permitted project is completed, Clean Water Act jurisdiction shrinks. It's reduced, whether because of a court decision or because the agency has revised the definition. And let's assume that the streams and wetlands that were the subject of the permit, that were permitted to be filled, would no longer be jurisdictional under the new standard. So in that scenario, is the developer, the permittee, still responsible for any ongoing compensatory mitigation requirements?
So as a non-attorney spokesperson, I think the initial answer is going to be yes in the scenario that you described. I mean, I'll take the two extremes, and this one, of course, is in the middle. But if they had finished the work and finished the mitigation requirements, there's no backing up. It was done and complete under the whatever rules in existence at the time. So it's they couldn't reuse those credits somewhere else if they had bought credits as a part of that permit. On the other extreme, if they hadn't started the work yet, we have had instances where permittees can come in to modify their permit based on the jurisdictional status and the jurisdictional laws that are in place at the time, or rules that are in place at the time. So they could do that up to, a permittee could ask us to revoke a permit if the entirety of their project now was not jurisdictional, if the work hadn't started yet. The nuance to your scenario is if the work had started and they had completed the filled activity, therefore fulfilled the permitted activity, the conditions of that permit would still apply. I don't think they could modify it at that point, but again, not an attorney. I'm sure that there is an underlying argument to be made there, and we've had some theoretical discussion of whether or not we, at the base legal level, have authority to enforce a permit over something that we don't have jurisdiction on. But I would say the fact that when they did the work, that area was still jurisdictional is the key in your example.
All right. Betsy, do you have anything to add?
No.
No?
But we
Okay.
would ask EPA.
All right. Well, then let's take it one step further. And let's say that the developer or the permittee satisfied its compensatory mitigation obligations by purchasing mitigation bank credits. And then it turns out that the area that was filled, that was the subject of the permit, is no longer jurisdictional. Does the mitigation banker have an ongoing obligation to offset the impacts to the now non-jurisdictional waters?
So again, I would say yes, if the activities have been complete, because everything was done under the jurisdiction of the rule that was in place at the time.
It'll be interesting to see if there are different views in the audience.
I would be disappointed if there weren't.
Yes, yeah, no, I anticipate that there.
And some of them may have core badges on.
Because you could see a scenario where if, well, we'll wait for them to come up with the scenarios. All right, a slightly different scenario. So a mitigation bank has earned credits by restoring an area that is considered WOTUS one day, and then there's a rule change or a court decision that now means that the mitigation bank site is not jurisdictional, it's non-WOTUS. But from a scientific matter, those waters contribute to the integrity of downstream waters. That's why it was permitted to be a bank in the first place. In that scenario, can the mitigation banker still sell those credits to compensate for impacts to the more reduced WOTUS?
So I'm going to take the easy way out on this one. I would say my best answer, and probably the one I should leave with, is if the district allows it, then the district has made a decision that that's appropriate. But I'll dig a little bit deeper because I do that to myself. I think that there are mechanisms that we could consider, even if it's not a jurisdictional area, exactly what you're laying out. That it may be full credit, it may be some modification in the way a credit's calculated. It doesn't necessarily mean that can no longer be included in the bank, but I think that's going to be very dependent on the exact situation of the bank itself.
Betsy, did you want to add anything?
No.
No. Okay. All right. All right. So we'll shift a little bit here, and if you do have questions, send them in. My iPad's gone to sleep, but you'll also have a chance with microphones shortly. Okay. So this one, and I'm sorry, this one is for Betsy and Tom. So Florida recently assumed the Section 404 program, and they're joining Michigan and New Jersey as the other two states that have done so. And there's some talk we heard, it's not in Virginia apparently, but there's some talk that other states will do so. So how does the state tribal assumption affect existing mitigation banks and in lieu fee programs? And how might it affect proposed or new mitigation banks or in lieu fee programs?
Me, if you want. Yeah, go ahead. So I can say we can speak inclusively for retained waters, those that the Corps would still have jurisdiction over, then the mitigation bank would still be valid for our program. My understanding, ultimately it would be the assuming authorities, whether that be the state or the tribe's decision on whether or not they would allow them to be mitigation within the context of their program, but our understanding is and experience is that typically they do. Quite often the assuming authority was a party to the banking instrument to begin with, and so that those banks aren't impacted, but again, that technically the Corps really doesn't have a say anymore in that part.
Yeah, I can only add some information about Florida that I have. Florida, of course, requested administration of the Clean Water Act 404 program, and EPA approved that request in 2020. The Corps does retain permitting authority in certain waters here, but those include tidal waters and Indian lands, among others. And I do know that Nebraska, Alaska, and Minnesota are actively pursuing whether or not to assume the 404 program.
Okay, thanks. We'll see if those states actually decide to commit the resources that are needed. Jason and Angela, I don't know if you wanted to comment on cooperation or coordination with state programs and how that might fit in.
I just wanted to make a comment about WOTUS.
Sure.
Just to go back to
Yeah.
you know, there's a big concern for us too. You know, it's not that we just care about the Endangered Species Act. That's certainly not true. I mean, if you sit at home and read the Clean Water Act front to back, and you should, you know, wildlife is in the very few first words of the statute. And
It is.
it's a primary, you can correct me, it's a primary public interest review factor. So we care about it just by itself. But certainly what happens in WOTUS is major consequences for implementation of the Endangered Species Act. A very stale number, but something like 28% of our consultations under DSA are with the Corps. Vast majority of that is 404. There's also Civil Works, the big projects in there as well, but most is 404. So that's the single largest source of federal nexus for conducting Section 7 consultations. And so if you know, the geographic scope of jurisdictional waters is, you know, cleaved by a certain percentage, then that has big consequences for how often we're able to consult. And it's not as simple as saying, well, folks that have a project affecting wetlands or streams, but that are, or where the wetland is no longer jurisdictional, they'll simply, you know, come in the door and access Section 10 procedures. I think it's not as simple or likely that will always happen. And we might not know what the, you know, some of the consequences are until, you know, we've looked back through remote sensing and other means to find out what we've lost because projects simply proceeded without our engagement. So just a note from Fish and Wildlife Service and WOTUS.
Yeah, that's an important note. I mean, I'm glad you mentioned that about the link between wildlife and the Clean Water Act, because sometimes you hear, oh, how the Clean Water Act, it's not a wildlife statute. Well, yes, it is, because Congress actually used the word wildlife. And, you know, generally now judges follow the plain language of the statute. The plain language says wildlife. So, Angela?
Yeah, I don't have too much to add beyond what Jason said. You know, the Corps is the single biggest agency for our consultations as well. They far outstrip any other federal agency that we consult with. And so, of course, we are interested in seeing a strong Waters of the U.S. Definition so that we can ensure that there is some regulatory oversight of activities in there, because you know, they are absolutely critical to not just our endangered species, but fishery species that NEPA manages. Wetlands and the waters are absolutely critical to our overall mission. And, you know, in terms of states assuming the programs, you know, because of that and because of our role in Section 7, you know, if states are going to assume, we want to make sure that they really have strong, vigorous programs and can really take those programs on.
Lisa, do you have anything to add in terms of?
Okay. We're kind of tangential to all of it.
Yeah. Yeah. All right. So I'm going to need some help with the iPad here. Okay. I always have trouble with technology. So the last question I have for now, at least, is it's 404 related. So the 2008 rule contemplates occasional audits of in-lieu fee programs. So how many programmatic audits of in-lieu fee programs have been done, and are there any broader lessons to be drawn from the findings?
So I don't have an exact number. Usually they're done in the district that's administering the in-lieu fee program, but I know several have done that. Of the ones that I know some detail on, I think the lesson learned is where there are failures to meet those requirements, understand why and how to prevent them. I mean, that's common sense. And also have a contingency plan. What happens when they're not met? Because typically what we find, if they're not able to find sites and provide it, it's due to a paucity of sites. And you know, our first desire would be, well, then go buy bank credits to supplant it. But often, if you know, they can't, if the in-lieu fee program can't find sites, chances are there may not be enough banks in the area either. So have a contingency plan if those credits aren't ultimately produced.
I don't have a list of all the ILF audits that have taken place since the 2008 rule, but we're aware of Virginia, Alaska, Tennessee, Ohio, and Kentucky, and there may have been more that we're not aware of, or I'm not aware of. Some of the additional lessons learned from the audits is clarifying the details, whether and how this to be spelled out in the ILF instrument itself. So what type of audit should be done, if it should be a fiscal or a programmatic audit, what frequency should they be done. 5 years is generally a good standard. Who would pay for them? So if a good approach to an ILF audit may be to set aside funds as part of the program to fund it and build that expense into the cost of credits, and also who might conduct these, such as an independent third party. These audits have been helpful in identifying aspects of the in-lieu fee program that are in need of revision, and some audits have been able to highlight the need to revise program fee schedules because an ILF program may not be bringing in sufficient funds to cover those expenses. They can also highlight some financial management practices that could be improved through more consistent and transparent adherence to the rule. And another key lesson that's been learned is that if there's concern about operation of the ILF program itself, it's best to pursue the audit of that program as soon as possible, so any issues could be addressed before they become more significant.
All right, thanks. Yeah, I think that's something that needs to be dealt with up front in the program instrument about how it's going to be financed. So you don't have to have that discussion afterwards. And the Environmental Law Institute has published a guide as part of the guides that it has for improving in-lieu fee implementation. And so one of them does deal with programmatic audits. So let's, you've been very patient listening to me ask questions here. Do you have specific questions? Please raise your hand. We'll have a roving mic. I'll see if we've got any. All right. Are there any good ones? Are they fair? Sure. Okay, for the Corps and the EPA, monitoring and mitigation data is important for the design of mitigation projects and evaluating mitigation performance. Is the Corps or EPA planning to develop a public repository of monitoring and reference data?
So, at this point, I mean, once again, I'll put it on the list of things that we have considered, but there's no active effort to do that.
I would just say generally that EPA continues to be interested in supporting efficient tools to help compensatory mitigation. We've had a couple presentations at this conference about the workbooks that were developed recently. We talked about a review of the mitigation estuarine marine habitats that was presented yesterday, and we're working to document some potential monitoring and performance standards available for restoration of dynamic and alluvial valleys, a stream resource that has not been currently considered, or is rather underrepresented in 404 compensatory mitigation outcomes. So while we have done some of this work before, we continue to be interested in hearing more about what tools and trainings and other resources would be helpful to improve efficiency and to improve mitigation outcomes.
Okay, thanks. Let's see, there's a question for everybody. So the Biden administration has identified environmental justice as a priority. Are there plans to incorporate environmental justice in policy guidance and decision making? And I you know, especially we've got a few, you know, few popping out, but
Sure, I'll start. The policies that we're publishing right now do incorporate mentions and instructions to staff to take those factors into consideration within our authorities. But certainly, you know, that was something that came out of the OMB review process that those policies went through in recent months.
I echo that for the BLM. We are diligently trying to incorporate our environmental justice policies in all of the actions that we are taking. We have a lot of momentum on that front at the moment, and we're moving forward, getting more environmental justice integrated more and more into our projects, and looking at it and ensuring that we are taking that into consideration and account, and actually have more direct involvement with people who lack some of the representation sometimes.
Yes, and for us, so NOAA Fisheries intends to issue its environmental justice strategy at the end of May, and every office and every program is developing an EEJ engagement plan to make sure that not only are we talking to underserved communities, but that we also identify them. We may not be aware of all of those who may be interested in the work or be affected by the work that NOAA Fisheries does. And one of the reasons why the Inflation Reduction Act funding has not been appropriated or allocated yet is because we are still undergoing tribal consultations. NOAA Fisheries has a really critical relationship with the tribes. They're co-managers with us on many of our species, and they are a really important part of our environmental justice strategy.
The administration has emphasized appropriate consideration of EJ in all programs, including 404 permitting and compensatory mitigation. On the permitting side, EPA has been working to develop a fact sheet as well as a module for the Watershed Academy, which is online self-paced training modules focused on appropriate consideration of environmental justice across clean water authorities, including 404. In terms of compensatory mitigation, EPA has been working to identify what resources are needed to support appropriate consideration of environmental justice in compensatory mitigation decisions as well.
Yeah, and as I mentioned before, we do have the guidance from the Assistant Secretary on incorporating environmental justice in the overall Civil Works program. And even though there's yet to come a specific regulatory module of that, I guess, there are tools identified for delineating those communities and identifying those communities. And we're also looking at various ways to better outreach procedures to make sure we're incorporating those communities in the decision-making process for permits as well as mitigation sites to make sure they have the information that they need. Yes.
Okay, thanks. Let's see, so Tom, this one is for you as well. Kind of a question, but could be interpreted as a plea. Could we have a future with a publicly transparent view of all or most data on ORM? And ironically, this is meant to be submitted anonymously for a lack of transparency. But go ahead.
The short answer is yes, and that's part of our vision of what we're doing with this bill funding. We're working several different things, improvements to ORM, I mentioned in another session earlier today, one of the things we're working on is what's called a regulatory request system, which will be an online interactive portal for the general public. We hope to at least release phase 1 of that sometime this year so that the general public can go in and get information that you'll be able to apply for certain permits and track the status of that. But eventually that will be linked with ORM, linked with Ribbits, so that we can pull that data together. Right now we have an internal data viewer for our regulators. We haven't worked out the kinks of making, through legal channels and our firewalls of making that publicly available, but we want to get there. And so, it probably won't be this year, but that's definitely something we're working with this bill funding.
Very good. So this question's for, do we have any questions? Yeah. We got a live question here? Yeah.
Just want to say, first of all, thank y'all for being on this panel as a regulatory addict. I just really appreciate all y'all being here and answering all these questions. I'm also an addict to WOTUS, and so I just can't help myself ask a technical question about WOTUS. So the current rule that's out there that's in effect in 24 states or whatever it is right now, the last paragraph deals with intrastate waters, not as a category not covered by the other categories in paragraphs 1 through 4. And there's two subparagraphs there, paragraph 5I and a paragraph 5II. I deals with relative permanence, and II deals with significant nexus. When you get down to that category, you're talking about intrastate waters that might have a significant nexus. My question is, as compared to the Rapanos guidance, 2008 Rapanos guidance that we've been used to dealing with for years and years and years, there's a lot of references in the Rapanos guidance to adjacency. And it seemed like to me when I read that paragraph 5II that maybe there was a little bit, it was a little bit of stretch beyond what we were traditionally seeing as considered jurisdictional under the Rapanos guidance. I'm ambivalent either way. I'm just curious because I'm an addict to WOTUS. I just want to know, was that sort of the intent that last paragraph might go a little bit beyond the Rapanos guidance? I realize Rapanos informed that rule, but there were other factors that were considered in that rule as well, and I just wanted to know if that was the intent.
You want that one?
You can start.
Do you have a written answer to that question on your paper there, Chief Valente? Because that would be really impressive if you did.
Just quote the text. So I will say the rule was developed by the agencies. I think it's even included in the economic analysis. The intent was, or the expectation was, it wasn't going to significantly or even measurably change jurisdictions. To my knowledge, there was no intent there to expand.
I unfortunately am not able to answer your question. I can only refer to the WOTUS website, and that the fact that the agencies have put on a number of webinars associated with WOTUS recently, and those presentations and other information are available on the website, but unfortunately I
You
don't.
did have it written down there. That's it. Wow, I'm blown away. No, Chief Walker, that does answer my question. I appreciate it, and it wasn't meant to be a trick question. I was just curious. I appreciate it.
Thanks. Let's see, we have a question over here.
Yeah, hello. There's been a number of updates and amendments to, and plus your policies on the Endangered Species Act over the last few years. Is there any interest in updating the Section 7 handbook to incorporate those?
So, as I mentioned earlier, in June, the services should have proposed rules to revise the Section 7 regulations out for public comment. And my understanding is once those regulations are finalized, the services will be updating the handbook. That's the intention anyway.
We have a question online for Jason saying that certain Fish and Wildlife Service field offices seem to remain resistant to conservation banking and will not engage in meaningful discussions. So while the Fish and Wildlife Service as an agency is working to emphasize support and resources for conservation banking, it may not be trickling down to the field office level where decisions and consultation processes would play out. Do you have any comments or thoughts about that?
Well, that wasn't a question, but
Yeah,
I'll
more of a comment.
talk about it. So conservation banking, as a practice, certainly came out of, crucible, Sacramento, elsewhere in California, and is spreading nationwide. We're going to be adding, I know more states are coming soon, but yeah, it's hard to respond to that. If we're putting out national policy, and we are, that's our policy, that conservation banking is one of the compensatory mitigation mechanisms that we are officially blessing with our policies, and we are working towards a regulation that will lay out those things that a prospective sponsor would need to demonstrate in order to secure our approval of a mitigation or a conservation banking instrument. And those are the things that are controlling upon any given field office's programs are willing to implement, right? And the rest is down to culture, certainly. And I think as these policies take hold and conservation banking grows, hopefully, following issuance of a regulation, that we will see it spread, regardless of past interactions between the industry and certain offices.
And I think if you sort of go back in history and look to see how wetland mitigation banking developed across the country, there were certain core districts that did not warmly embrace the concept at first, and it can take time. Do we have any final question? Yeah. Okay, we got a final question back here, and then we're going to let you all have a final word.
This is a similar type of thing as what Jason just answered, but I will frame it as a question, Tom. If we have field offices where our staff are interacting with the Corps, but they are, from what they tell me, the Corps are not implementing the regulations as written, and our staff will tell their Corps counterparts, look, this is what your regulations say, this is what you should be doing, and the Corps staff just kind of blow us off. What's the best way for our staff to try to move beyond that kind of an impasse?
Talk to the reg chief.
So go to their boss.
I mean, if it's a, yeah.
Okay.
Okay, all right. Asked to speak to the manager. Let's let you have an opportunity for some quick final thoughts. We'll start on the left. Tom?
Thank you, and I just want to say thanks for inviting us to this and putting this on. It's been a great week, and I've learned some things and reinvigorated some brain cells, so let's keep this up, and hopefully we can present much better data next year.
I would say thank you very much for the opportunity to be here. I was lucky enough to come on Tuesday, and I've learned quite a bit this week. Really enjoyed the opportunity, and I wish everyone a wonderful weekend.
And I would echo the thanks. I appreciate the opportunity, and it's been another great conference, and thanks to Carlene and her group for organizing yet another great conference. I was fortunate to be able to spend a few days here this year, and I always learn a lot when I come, so I really appreciate the opportunity.
Yeah, thank you all. Thank you for the invitation. Thanks for a great conference, Carlene. And I am sorry Gary Fraser couldn't be here. He holds this industry in very high regard, and everywhere we're going in mitigation, with our expanding mitigation bookshelf of policies and regulations, point to this industry having growing importance to the Fish and Wildlife Service. Thank you.
I would also echo thanks to inviting me here and the BLM and having this conversation. We're really excited as to what comes next. We're getting all of our ducks in a row to have a really robust mitigation program and and you're so involved in all of that in the industry and everything. So thank you for having us. Thanks for your time, and hope everyone had a good conference.
And I would like to thank you all, not for attending and participating, but really for what you do and the improvements that you make on the ground. Thank you. And I would also like to thank our panelists, not just as panelists, but for their service. I don't think we do that enough. So thank you all, and safe travels.